So far as the role of an advocate in shaping the decision making in a company is concerned, I will like to divide in two parts because you have used one more word, ethical. So what is ethical? Perhaps it changes meaning in a different frame of reference.
Mr. Vinod, over the course of this conversation, one thing that really stands out is your approach. It goes beyond just legal frameworks or ticking compliance boxes. And I think that's where the real power of law lies in guiding conscience, not just conduct. Hello, everyone, and welcome to FaceTime with Leaders, a podcast series by Directors Institute, World Council of Directors, where we bring you face to face with minds that have shaped industries, upheld ethics, and championed excellence. Today, I have the privilege of speaking with a man whose voice carries weight in the courtroom and whose counsel stirs course for companies, Mr. Vinod Bhide.
Good morning, Sunny, and good morning, the audience.
Good morning, Mr. Vinod. Mr. Vinod, your name is synonymous with integrity and depth in legal practice. From civil to corporate, criminal to consumer law, there is hardly a pillar of justice you haven't influenced. 25 years of relentless courtroom presence, high stakes advisory, and thought leadership. That's not just a career, that's a legacy in motion, sir.
Yes, thank you for your kind words. But I believe in doing right things, however they may be the complex situation.
Absolutely. And complexity is where you thrive, right? Whether it's representing top corporations before judicial commissions, decoding regulatory mazes, or authoring legal commentaries, you have built a reputation for clarity in chaos and precision under pressure.
Yes, definitely. You have used the term, what you called it as a legacy in motion. That means doing the practice in such a way that it will create a long-lasting influence on the days to come. But for that, I believe that one has to be a student forever. So though I have completed 25 years of my practice, I believe that still today I am a student of law, and I like to learn more and more from my day-to-day practice in the course.
Absolutely. Absolutely. And that mindset is exactly what today's episode is all about. Navigating the legal labyrinths with clarity, integrity, and vision. So, Mr. Vinod, you have spent over 2 decades navigating courts, advising companies, and shaping legal outcomes. But we know every seasoned professional has a story that often begins in the most unexpected ways. So, let's start there. Take us back to the beginning. What did the early days look like, and how did your path in the legal world unfold?
Perhaps you must have observed that I have completed my law degree in the year 1992, but I started my practice as a lawyer from 1999. So the question you may get that why there was a 7 years gap. So basically, I want to introduce that I am a first generation advocate in my family. My father was a businessman. From the school days, certainly I completed my schooling and college up to the science degree with mathematics as principal subject, Bachelor of Science from Pune University at Sangamner in Ahmednagar district of Maharashtra. While doing my college education, I was helping my father in his business, and at the same time, as per his ethics or teachings, I was a self-employed person. I was engaged as a investment consultant and insurance consultant. At the same time, I was learning law also simultaneously. So those experiences of life as a salesman, as a marketeer, as a investment and insurance consultant has also helped me in or influenced my career, further career as a lawyer. In my college days also, I was a NCC student. I passed the Army NCC B certificate examination in O grade, that is outstanding, and C certificate examination with A grade. That has also is having a long impact on my life so far as the discipline and timely compliance is concerned. So in the year 1992, I completed my law degree from Pune University when I attended the colleges at Pune as well as last year at Nasik NBT Law College. And why there was a 7 years gap, that certainly due to those agencies and my earlier preoccupations, I was engaged, I was having business in my name. So for joining any professional career, one has to accept it as a full-time profession. So only in the year 1998, I transferred all my businesses and preoccupations in the name of my wife, and thereafter I accepted it as a full-time profession in the year 1999, and that's thereafter. Now for last 25 years, I am in this profession, and I am happy to be and honored to be. So far as my career as an advocate after 1999 is concerned, I am greatly influenced by my senior advocate H.V. Beg from Sangamner, who is an eminent criminal lawyer. I am thankful to him also for that. So far as the career of an advocate is concerned, 10 years or 25 years period is not that much long, because this is a profession having very longer waiting period. So I am thankful to my senior, because from the day one, he allowed me to pursue the cases given by his clients to him. And that was a beneficial situation and surrounding for me. So I could develop my civil as well as criminal practice at Sangamner. After completion of a career as an advocate for about 8 years, I got one opportunity from a company at Jalna in Maharashtra to accept an assignment as a retainer advocate for all their matters in various courts all over in Maharashtra. Certainly, I was thinking over to shift to Aurangabad for practice before the High Court, but I took that opportunity favorable to me, because Jalna is again in Marathwada. Basically, territorial jurisdiction of Aurangabad Bench is Marathwada, including Ahmednagar district, from where I belong. That is Sangamner is an Ahmednagar district. So I accepted that opportunity, but that given me a very, very memorable teachings as well as experience. Because when I moved to Aurangabad and Jalna for practice, I got certain other dimensions of legal litigations like debt recovery, consumer protection, because such types of litigations were not there at Sangamner. Certainly, I was doing the practice before session judge. That's why, so far as the criminal trials and civil property disputes, etc., are concerned, I was conversant with. But when I moved to a better station, certainly so far as the corporate agreements and the dispute arising out of it, debt recovery tribunal, high court practice. So I got that experience in those 3 days assignment. Basically, that assignment was for that the company was planning to go either for a public issue or for a institutional investor. In both the cases, the party is required to give the statement before SEBI about their pending litigations. They may be criminal, they may be civil, because the investor certainly wants to know about the prospective liabilities or profits which may arise or which may come from such pending litigations, because there is no any time limit for that. So in that 3 years span, I certainly I can be proudly mention that I could resolve their requirement because they succeeded at the end of the 3 years. The all sorts of litigations, civil as well as criminal, were reduced to some 2 digits, or it can be said that less than 10. And that's why they could get the foreign institutional investor fund as a equity, and their business was they could succeed in that their achievements. But simultaneously, in these 3 years, I could get an experience to assist the stalwarts in law. I should name Mr. Sunil Manohar from Nagpur High Court, who subsequently became the senior counsel, as well as Advocate Zaka Haq, who not only became thereafter a senior counsel, but he was elevated as High Court and now he is retired. In the same manner, I could assist Advocate Anil Bajaj from Aurangabad and senior counsel appearing before Bombay, that is principal seat of Bombay High Court. But these experiences not only shaped an advocate in my place, but I got opportunity to assist them and learn them a lot from them. It may certainly there was a variety of litigations in these 3 years, and that gave me courage, or that motivated me to reaffirm my decision to shift to Aurangabad for a practice before the High Court. So, and in the year 2011, I shifted at Aurangabad, and now since then I'm practicing before High Court as well as Debt Equity Tribunal. We are having Debt Equity Tribunal at Aurangabad, as well as the Consumer State Commission. Certainly, I have limited or restrained myself to these 3 forums only, because due to time constraint, if you personally are not able to appear before the courts, I believe that depending on your colleagues or juniors, that will not be a proper for your clients who are having faith in you. So I have limited my practice to High Court, Debt Recovery Tribunal, and Consumer State Commission at Aurangabad. Certainly, in the COVID days, when the online hearings started and were made compulsory by the then Chief Justice of India, Mr. Chandrachud, that got also us an opportunity to appear before other benches of High Court and even the Supreme Court. In today's days, we can appear before Supreme Court also from Aurangabad, but certainly in very low number of cases, because sometimes the court requires that you should appear before the court not online but offline. So it should be possible, then only you should accept the assignment. So I'm not attending the Supreme Court regularly, but other benches of Bombay High Court, certainly I'm appearing. So this was the journey of 25 years, but still today I'm learning many things, and I'm influenced by these stalwarts. Certainly, when I shifted from Sangamner to Aurangabad, it was a challenging decision for me, because when a person crosses some age limit, age constraints, you get some many other, I will not say botherations, but limitations so far as your liabilities towards your family and everything is concerned. So it was a challenging decision, because after completing about 8 years practice at Sangamner, and there were some well-wishers were of the view that I should not go to the other station because my practice was settled. But I accepted the opportunities, but that gave me an opportunity to explore my practice before the higher forums. and I'm happy in that. So that is the journey of last 25 years, I can say.
And what an incredible journey, Mr. Vinod. It's
Yes.
rare to hear such a grounded and real account of what it takes to build a meaningful career in law. And I think our audience will really resonate with the clarity and purpose you bring. Truly.
Yes.
All right. So moving ahead, Mr. Vinod. Now, this one
Yes.
really stood out when I was going through your journey. And I have to say, not many legal professionals get the opportunity to defend a matter before a Judicial Commission of Inquiry. And
Yes.
that's not your everyday courtroom. That's a stage reserved for matters of serious public interest. And it requires
Yes.
a whole different level of composure and clarity. So, Mr. Vinod,
Yes.
take us into that experience. What was it like stepping into that moment, carrying that kind of responsibility?
For that, we will have to go in the past about 2 decades, because I remember that I was only a 3 years advocate, I can say. I remember the date, it was 25th June 2001, when 3 Adivasis from Puntamba. Puntamba is a place near to Shirdi, for your reference. It is in Kopargaon Taluka of Ahmednagar district in Maharashtra. The 3 Adivasis lost their lives in police firing. So there were complaints and cross complaints. It was the claim of the state authorities that for certain demands, they arranged or 3 or 4 named persons, that is leaders of that Adivasis, those Adivasis, called a morcha, that is agitation, in front of the police outpost at Puntamba, which the situation rotten, and due to the encouragement given by the alleged leaders, or it has turned into violence. The mob become violent. There was stone pelleting. There was attempt to put on fire the government estate, government property. There was an attempt of, certainly I should use alleged attempt, word alleged, because nothing is derived from that. The accused persons were acquitted subsequently in the criminal trials. There was an attempt of assault on a police officer amounting to attempt of murder, or there were also allegations of committing an act of molestation of a woman who was residing inside the police campus, as it was a outpost in the you can say in the rural area. So there was the facility. And as against that, the Adivasis were with the story that certainly they admitted that there was a procession or morcha agitation in front of the police station, but only the representation was given to the Tahsildar, and everything was finished thereafter. And after a gap of about half an hour or at least 20 minutes, for the reasons best known to the police officer, he was at the rank of a police inspector, who chased 4 named persons, that is the Adivasis, and murdered them in a primary school at a far distance from that police outpost. So due to these cross news, they were also got very good, very vast coverage in the, not social media was not there, but certainly on TV channels. And fortunately or unfortunately, the Maharashtra State Assembly was in sessions, and that created much more problem. Immediately, the state government firstly called the magisterial inquiry. But there was a funny thing that magisterial inquiry means the inquiry was expected to be done by the SDO, that is Subdivisional Officer Shirdi, who himself has given the orders for police firing. So the person who was an accused was appointed as a judge in his own case. But that lasted for about a week or 2. Again, the questions were erupted in the state assembly, and thereafter that pending inquiry was called off. And this, what you referred to, the judicial inquiry, was was declared, that is under the provisions of Commission of Inquiries Act. And the sitting district judge of Ahmednagar district court was appointed as the one-member commission, and I got opportunity to represent the Adivasis before that commission. Basically, that was also a additional story that as per the rules, because in Judicial Commission Inquiry, there is not a judgment. When commonly we appear before any court, it may be civil court or a criminal trial. After recording the evidence, it gets concluded in the form of a judgment to be pronounced in open court. In Judicial Commission, commission is established for certain points which are specifically referred to it, giving a fact-finding report, you can say, to the state government. And ultimately, state government may take decision what to do after that report. So there is no judgment as such declared by the commission, but certainly a report is submitted. And when about if I'm not remembering the exact number, but about 1,300 or 400 witnesses gave their statements on oath before the registrar of the commission, and thereafter both the sides gave their list of witnesses to whom they want to examine before the commission. The commission commences its business after examining some of the witnesses from the side of the Adivasis. For the reasons best known to them, they decided to change their advocate, and thereafter the assignment came to me. Certainly, I know the reasons for that, but I am not supposed to disclose it in openly. So thereafter, somebody suggested that if you want to get a good representation, go to Mr. Advocate Bhide. Basically, it was suggested to my senior, but he expressed his faith in me and gave this assignment exclusively to me. I was attending the Ahmednagar session judge continuously for about 40 days. Every day, at least 7 to 10 witnesses were examined. I examined number of about 80 witnesses of the prosecution. I should not use the word prosecution, but the state, who was one of the party who were supporting the case of police firing, and who were basically the reference given to the commission was that whether these 4 named persons have provoked the Adivasis to commit the offense of stone pelleting, firing in the sense to put the property on fire, then molestation and attempt to murder of a police officer, and so on, and whether the police firing was necessary in the given set of circumstances. So they want to justify it. That was the one side. And whether they want to make the leaders of the Adivasis accountable for that. And other side, other point of or opposite point of reference was that whether it was not at all a police firing, but it was a intentional murder of 4 innocent persons by a police officer without any authority, and so it amounts to a crime, and for that he should be prosecuted. So after getting this opportunity, when I appeared before the district judge, that is the commissioner, I prayed for and certainly he was also kind enough to give me a continuous 4 weeks adjournment. But in that period, I gone through all these documents, all the facts involved, all the police papers, including the post-mortem reports, police firing reports, and so on. That gave me a very thorough view to analyze the facts so far as criminal trials are concerned. the ballistic experts, how they can be cross-examined, what the science suggests. So far as the autopsy reports, what they suggest, that is a branch of medical jurisprudence, and that enriched my experience. And from that I can say, because I can give a short reference of the facts. It was a specific case of the police that it was a firing by the police from a 3.303 rifle. 0.303 rifle means a rifle, police rifle, which is having a diameter of 0.303 inches, which is approximately equivalent to 6 millimeters, because the subsequent generation of weapons are, their gauge is measured in millimeters. 0.303 rifles are perhaps we have taken from the Britishers. There the experience from my NCC career helped me. But if, as per the cross allegation, if it is a firing from a service revolver of a police inspector, its diameter is of 8 millimeter. And what is the distance between the bullet fired from the gun or whatever instrument it may be, and when it hits the body of a human being? That this distance also is very important to infer whether it was a firing from a distance of 300 feet or it was from a distance of 4 or 5 feet. Because from the police mortem, you can get the nature of injuries. When there are injuries of police firing, the inside wound, that is where the bullet enters your body and from where it exits, the diameters of both the injuries are also different. So by cross-examining the doctors performing the autopsies of all the 3 dead bodies, the 3 different doctors were there. Basically, teams of doctors was there conducting the postmortems. I could succeed in getting the suggestions or getting the opinion that it cannot be a police firing from a distance of 300 feet, but certainly it was from a distance of 2 or 3 feet. That was the suggestion, that was the opinion given by the doctor. So, to my mind, I succeeded in canvassing before the commission that it was not a police firing case, but it was a cold-blooded murder of 3 or 4, 3 persons at the hands of the police inspector. But certainly, I cannot say that I could succeed, because the judgment or the report is not in public domain. It is submitted to the state government, and for last 21 years, it is still with the state government, lying somewhere in the cupboards of the Mantralaya. And perhaps the subsequent, there are so many governments might have changed, but the politicians must have lost their interest in again giving a rise to this dispute, and nothing was subsequently taken. No action was taken by the state government till today. Certainly, the Adivasis faced a criminal trial on the basis of that is in the regular courts, and they are acquitted. And there was, but there could not be any prosecution against the police. Certainly, that is a pain in my mind. So that was the experience. But for me as an advocate, I got an opportunity to learn very huge at just early days in my career. And that helped me in my further practice as a lawyer before even High Court as well as Sessions Court. One can call it as a trial court. Because on the basis of that knowledge only, not recently, but about 5 years ago, I succeeded in getting a acquittal judgment from the High Court at Aurangabad Bench in a murder case where the session judge has convicted him, not only convicted him, but has declared a death penalty. So the accused who was warranted with death penalty was cleanly acquitted by the High Court. So that was the approach for analyzing, because on the same facts, the concerned advocate, my counterpart before the session judge, might have argued the case. There was, on the basis of the same material, the session judge might have arrived at certain decision. He held that he was the only culprit who has committed the murder, and it was so heinously or so with knowledge that death penalty can only be the appropriate punishment for him. But on the basis of the same facts, I could canvass the picture before the court that how the evidence led by the prosecution is not sufficient, or it cannot be said that the offense is or the charge is proved beyond reasonable doubt, which is necessity for criminal trials. And ultimately, there was acquittal judgment by the High Court.
Absolutely. But let me tell you, Mr. Vinod, this gives us a real sense of gravity involved in such cases. Not just the legal challenges, but the human side of it as well. The responsibility, the integrity, the calm, everything. That's truly, truly powerful, really. All right. Mr. Vinod, let's move ahead. You have spent years working closely with the Negotiable Instruments Act, and you have also written in-depth commentary on it. It's one of those laws that touches both businesses and individuals in such practical ways, yet it's often caught in procedural delays. So, sitting where you are, with the kind of experience you have had, what reforms do you feel are long overdue? And what needs to change to make it more effective and relevant today?
Yes, in the beginning, I should correct the word that it is not a commentary on negotiable instrument, but it is a referencer on negotiable instrument criminal trial. It is restricted to criminal trial only. That is section 138 onwards. In the year 1988, for the first time, because the Negotiable Instrument Act is of 1881, but there was no any provision for a criminal trial or punishing a person who gives or who issues checks from his account. But when it get dishonored in want of funds in his account, it was not punishable. In the year 1988, first time, the section 138 of Negotiable Instrument Act onwards are inserted in that. And from 1988 till today, the act is amended at least for more than 14 times, 1-4. So I will not say that certain reforms are still required, because the legislature is vigilant enough, because basic intention behind adding this chapter, making it punishable, is that there should be a faith in issuance of negotiable instruments in day-to-day business. And for that, legislation has taken sufficient steps. But so far as its appreciation is concerned, to my mind, certainly I should not say, because it is a blame. It is giving a blame to my own professional colleagues. But I still believe, I'm not afraid to say so. But I still believe that the advocates are lacking somewhere, because they are not having any knowledge of business. This Negotiable Instrument Act mostly, not only mostly, but in 100%, it relates with business. Unless what are the settled business practices are known to the advocate, because the layman, the accused, I will not say layman, certainly they are educated also, in not in that sense I am using the word, but whatever vocabulary he is having, he gives instruction to his advocate. But I am doubtful whether the advocate can succeed in taking cross-examination of the complainant, what is expected by the accused or not is a serious question. I will give you an example, because on the basis of a dishonored check, there are two remedies. One can, the complainant can go for a criminal trial, that is punishment under section 138, which provides imprisonment up to 2 years and also a compensation up to maximum twice the check amount. Certainly it is left to the discretion of the court, but simultaneously he can sue the accused, that is the defendant, for the amount of dishonored check. Now, this is not the only case where two simultaneous proceedings are possible. And the Law Evidence Act says that the judgment in one matter is relevant. It can be said to be relevant, but may not be binding in the another. For example, I'm giving you an example. Certainly, I will not refer to the names, but I got an opportunity to appear on behalf of an accused, again in a parthered matter, before the Chief Judicial Magistrate Sangli in Maharashtra, where already a civil suit was decreed against the accused. That is what, for example, I will say, imaginary figure, a check of rupees 5 lakhs was dishonored. The complainant, who was the holder of the check, sued the accused, that is the defendant, for that 5 lakhs with interest. And the reason was on the basis of the dishonored negotiable instrument, that is the check. After getting evidence of both the parties, the civil judge has given a verdict in favor of the plaintiff. A decree was passed to pay rupees 5 lakhs with interest to the plaintiff within so and so days. And when it becomes a relevant piece of evidence before the trial court, that is in criminal trial, it becomes very serious for the accused, or it becomes very difficult for the accused to canvass his defense before the criminal trial. Because certainly, though it is not a binding precedent for him, the judge is also a human being. He will say that a competent judge has already not convicted. Fortunately, it was not a criminal trial, but he has already passed a decree against you to pay the check amount, and he has kept you, has held you responsible for the check dishonor. Under such circumstances, in such a situation, after completion of the recording of evidence of the complainant, there is a section 313 statement of the accused. The court records the statement. The statement of the accused was recorded, and thereafter the accused came to me. He said that after listening to the information given by him, I was also wondered that when civil decree is already passed, there is very less scope for me to defend your case. But when I gone through the papers and what he narrated me, what he declared, what he disclosed the facts, the complainant was a broker. So there was not a direct business relation between the accused and the complainant. He was a broker. He was a manufacturer of starch products, gum, etc. And tapioca, that is a root, basically or mostly cultivated in Kerala. So the tapioca starch was purchased from Kerala parties. Even when the purchase agreement gets shape, even the purchaser need not have knowledge about the name of the party even. That is the role of the broker. He is a mediator. Supplier was from Kerala, certain party. And there is a business practice that when you are purchasing some goods of worth lakhs of rupees, for security, they take a blank signed check from the purchaser. who takes? The broker takes. Even the seller or the manufacturer did not know the party who is the exact purchaser. He is interested only in getting his money, and that also is routed through the broker. In very rare cases, it can be given directly by the purchaser. Under such circumstances, there were certain documents which were used and exhibited as evidence in the civil court, on the basis of which a decree was passed. But the nature of the document was that to Mr. So and so, that is a blank space, towards my purchase of so and so tons of starch, please find enclosed check number so and so rupees for rupees so and so, dated so and so. Everything was blank. And as it was blank and it was not addressed to any named person, there was certainly a place to defend the case of the accused in true terms. Certainly it was a chance case, because if the complainant, after entering into the witness box, will not cooperate in the sense he will not give the real terms before the court or pretend to be the holder of the check, then it was difficult. But he was also a perhaps misguided person. He was having he was cocksure about his case, and he said that when the civil court has already passed a decree in my favor, I should not worry. So when he came in under my cross examination, I refer the same letter that it is your contention, that is the contention of the complainant, that with this letter the check was handed over. He said yes. Thereafter I said that what was the substance purchased, so that it was tapioca. There were the transport bills, transport invoices, you can say, where there is mention of the party who has loaded the goods and where it is unloaded. Both addresses are there. Then I put him a question on the basis of that document, which was admissible to both the parties, because he himself has used those documents before the civil court. There was no opportunity for him to deny the documents, but certainly he was having opportunity to give his explanation, better explanation to my questions. But he admitted that guilty also. So then I put the suggestion. So these goods were sent by this ABC party from Kerala to this person at Sangamner. He said yes. So you have not sold anything to Mr. So and so, the accused person. He admitted that also. Then in the vacation period, when the case was assigned to me by my client, I could succeed in getting the payment receipt and ledger from that Kerala party. Then I asked him what is the name of that party from Kerala, whether they were known to each other. He said no. So there was no any occasion for him to meet that person. Then I referred to a new letter with permission of the court to lead additional evidence in cross-examination. I referred to that this party says that nothing is in arrears or nothing is recoverable from this accused person as on so and so date, because he has given the statement. To that he said no. Then I said that as per this letter which you have admitted, this is not addressed to you. He was bound to say yes. Under such circumstances, the court appreciated the evidence and said that the complainant has not proved that he is holder of the check. There are two defined terms in Negotiable Instrument Act: holder or holder in due course. He was neither a holder nor a holder in due course. Holder or holder in due course can be the party from Kerala. So that was a misuse of the blank signed check. But I could canvass this defense before the court because I was knowing the ABC of business. What are the practices? I will not say that the advocate who must have defended him in the civil suit was a foolish person, but certainly he was not knowing the business practices. So he could not put those questions to him when he was under cross-examination before the civil court. in the civil suit. So these are the challenges. When there are the checks are dishonored from are issued by a company or a firm, both the terms are defined in Negotiable Instrument Act differently. They have nothing to do with Companies Act. So if it is a issued by a company and it gets dishonored, then even after proving the case, to whom you will convict? A company is not a human being. It cannot be convicted, put into prison. So there is a concept of vicarious liability or vicarious liability of the directors or even the employees and officers who may be either signatory, or even if he is not signatory, but having the knowledge that such check is given, we have to honor the liability so created, and even then he fails in that, then he can be convicted under section 141 of the Negotiable Instrument Act. That is the vicarious liability of the directors and officers when the offense is by company. In that also, for succeeding in a check dishonor criminal trial, sending a demand notice to the accused is a condition precedent. Sometimes, as the advocates, certainly I should not blame. I'm repeatedly doing the same mistake, but I'm blaming the advocates. But I have observed in my practice of last 25 years that notice is sent, but it is sent in the name of directors, not in the name of company. But company is a legal person. Not only legal person, it can be said to be the principal person. And the directors only can be implicated in their vicarious liability. So principal accused is company or the partnership firm. Unless it is named independently, it is held guilty independently, the directors cannot be under the concept of or principle of vicarious liability. Such blunder mistakes when I come across, then it is painful. I believe that it is not at the mistake of the client, but sometimes it is due to the lack of knowledge on the part of advocate, certainly. So there is necessity
Absolutely.
of teaching the advocates also, and basically they should know the business. That is the requirement.
So, but that's such an eye opener, Mr. Vinod. Coming from someone who has worked at the ground level of these cases, this really highlights how law and reality sometimes drift apart. Great. All right. So, moving ahead, Mr. Vinod, over the course of this conversation, one thing that really stands out is your approach. It goes beyond just legal frameworks or ticking compliance boxes. And I think that's
Yes.
where the real power of law lies, in guiding conscience, not just conduct. So, from your perspective, what role do you believe lawyers play in shaping a company's ethical compass, not just ensuring it stays within legal frames?
Yes, so far as the role of an advocate in shaping the decision making in a company is concerned, I will like to divide in two parts, because you have used one more word, ethical. So what is ethical? Perhaps it changes meaning in a different frame of reference. So far as your in-house work is concerned, that is, so far as the relation between the company and its employees or your vendors, when everything is smooth going, then you can say that it is every practice adopted should be ethical, no doubt. But when it comes to a litigation, because we are related mostly with litigations and not with the in-house work, what the company administration requires. There is distinction between these two fields. Certainly, I had opportunity to visit a number of companies, or to consult, to give advice to even the board members as well as the top officials, administrative officials. They are having the legal department, but there are no such two compartments separately. So when it comes to the litigation part of it is concerned, we say that everything is fair in love and war. So this is something like a war when it comes to the, and again I will make one amendment that everything is not permissible. There also it is ethical, because in war your ultimate aim is to conquer your opponent or defeat your opponent. But in litigations, I will say that if you want to succeed, you should concentrate on getting the relief and not defeating your opponent. So far as my advice to the corporate houses with whom I am working as a panel advocate or some advisory work or on occasion basis, I am not interested in defeating their opponents. I am interested in getting relief to them. So, because that is the distinction between the war and this litigation. Because sometimes the litigant litigate the matter for years together up to the Supreme Court and spends much more hard-earned money. And ultimately, certainly he may succeed in defeating his opponent, but what he gets, nothing. Or for a recovery of rupees 10, he spends 10,000. So certainly to that extent only this ethical practice is necessary. But I will, can I explain from one example?
Yes, yes,
Sometimes,
please go ahead.
sometimes the top officials and even the board members, due to lack of perhaps legal background or legal knowledge, commit blunder mistakes that goes against them in litigations. For example, in some I had an experience to advise some company. They had installed it is in the past a power generation co-generation plant. It was a second-hand co-generation plant purchased from Uttar Pradesh and installed somewhere in Maharashtra. There was a service contract from the purchaser that their team will come, they will install, then there will be trials. Thereafter, there will be the actual production for a certain time of months or 1 or 2. They will render their services till production of that power generation, and thereafter the contract will conclude. But at every stage in the agreement, whatever fault you have observed, you are required to call upon them to correct it. And unless you call upon them to correct it, you cannot saddle a liability on them for its non-performance or something like that. So everything worsened. Now neither the machinery, the plant is installed at your site, but neither they are coming for its maintenance. Nothing is a power generation. Huge amount is unnecessarily invested. It may be a dead investment now. And under such circumstances, the matter was referred to me. When I gone through the contract and their performance, there was no performance on our part, though real terms are with my client, but nothing was in their favor. Then I requested, or I advised the manager concerned of the company to issue them a fresh notice. Then also I have come across various time on various occasions the word used as when the notice is sent on the letterhead of advocate, they call it as a legal notice. We have sent him a legal notice. I fail to understand what is the difference between a legal notice, whether there is any occasion to call it as an illegal notice. What is this? As per their myths, when it is on the letterhead of advocate, it is a legal notice. And if they, as of their own, they shoot a email from their mail ID. No, it's not a notice. We have not sent him any notice. I said, give me the copies of your communication inter se, who were the responsible officers from both sides. From that, I could get that the officer sometimes has cried that please perform this, please perform that. That is in a notice. Because what is basically notice? Notice word is not defined anywhere in the law. Notice means it is the requirement of the law that for putting an answerability against, for imposing any answerability against your opponent, you have to call upon him to perform certain things in time-bound manner. And if he fails, then you can raise your suit or your complaint before the court of law. So this demand, if it is properly spelled, explained in a letter, even a love letter can be a legal notice. It is a notice. Why? For what reason it should be from advocate's letterhead? On the contrary, many of times I advise my clients, though the draft is given by me, I do not issue the notices from on my letterhead. I direct the concerned officer, put this message in your letter, it may be in hard copy or email, and shoot it. Normally, the other side also take it in the same manner. They do not call it as a legal notice, and perhaps if my client is sufficient, fortunate enough, they do not bother to reply even it. And that goes in benefit of my client. So these are the practical things. You cannot say that it is an unethical practice on the side of my client. Certainly from me. But taking admissions from other side is also a skill. And under such circumstances, again, to the main topic, that is the example, they issued those notices, they were not properly replied. Then we put the case before the court, and they came for compromise, and everything was settled. To some extent amount was paid, to some extent for next six months the agreement was extended without any consideration, and they gave they render all services for proper commissioning of the plant and so on. So these are the things. To this extent, the world ethical practice is objectionable. What I have narrated just now, everything is ethical. But in some other frame of reference, one may say that you have cheated the other side. It is not cheating. It is a skill to get admissions from the other side, because in absence thereof, you cannot put your claim before the court of law. So these are the things. And for that,
Absolutely.
For that, I have observed that sometimes the administration of a company is quite efficient enough, but they do not take decision. They wonder for the consent of the director. Perhaps he is not having that legal background or knowing the hitches in that. And not taking a decision is more dangerous than to take a wrong decision. So that should be avoided. That is the advice to the corporates.
Rightly said. It's reassuring to know that behind the legal language and clauses, there are professionals like you guiding companies to do the right thing, not just the required thing.
Yes.
Okay. So, Mr. Vinod, you have already made a deep mark in litigation and corporate advisory. But as you look ahead, what are some of the aspirations that drive you? And more specifically, as you step into the space of boardrooms and strategic leadership, what kind of roles or contributions do you envision for yourself there?
Yes, certainly there are, whatever practice I have done so far is concerned, advising the directors or the top officials. It was not for framing their policies. It was only a case basis opinion or case basis advice given. So in my considered opinion, when I will get the opportunity to become an director, certainly I will get opportunity to shape the decision making process of a corporate house that may help them. Because as I said earlier, and you use the word that not only doing the things properly, but or you have used the phrase just now. But what should be the performance is, I'm basically a science student, so I correlate with those terms also, though I'm a law professional. In chemistry, it is for confirmatory test, it is said that what is required, that is what is necessary and sufficient conditions. So you put only those things which are necessary and what are sufficient. You should not talk lesser and it should not be more than that also. So under such circumstances, so far as shaping the decision making of a corporate house is concerned, there should be a specific understanding between the officials and the directors, and especially a thorough legal knowledge on the part of both of them. Or if a work is assigned to to some official, he should get that much liberty, because I said I referred in earlier example also, it is not the thing that the concerned officer, he may be a general manager, he may be a manager of the concerned department, he was not knowing the things. He was knowing that I should call upon the other side to perform his part, otherwise we will not have anything in our hand, then to corner him. But they wait for the decision of the directors. Nobody is ready to take risk on his part, because perhaps it may have monetary repercussions also. So there should be a fair understanding between the top officials. I have come across most of the cases where I found that there was a lack between understanding between the two. For example, there are some very funny things that when some employee resigns from his job, after completion of the notice period, it is expected that you should pay him the full and final and the experience certificate, if any, or something like that. You do not have any authority to stop him after the notice period, or the payment if he does in lieu of the notice period. But just only because of some ego problems or something like that, the officer, though he is knowing that I am duty bound to pay or finalize his full and final payment, he do not do. He only keeps reporting to the director. Director keeps mum, and unnecessarily the matter crops, which is not even good for the image of the company in public at large also. And nothing could be derived. When it was referred to me, I said that you don't have any option. Keep your egos at your home, pay him immediately. Otherwise, if he goes in litigation, that will be harmful to you. So, and what I mean to say that there should be a clear understanding between the two. And one more area of legal department which I want to highlight is that all the companies are having very large legal departments. There might be some president or general manager, managers. The companies to whom I am rendering services of advisory, certainly the staff, their junior managers are also highly qualified than me. Perhaps they have completed their LLM. But the thing remains is that what they keep doing is they are always the legal departments are always busy in renewing the licenses, the statutory compliances, whether the all reports are filed or returns are filed within time limit or not, keeping watch on the pending cases before the court, taking dates, meeting the advocates, and so on. But there is absolutely there is no department which can take care of preventing the litigations. I am harping on this point, and already I advise many of the companies for preventing the litigation. That gives you a peace of mind, as well as saves your time from these litigations and their adverse effects on you. And for that, various measures needs to be taken. For example, there is in the Negotiable Instrument Act, there is one concept, that is a check given for security, whether it can be actionable under Section 138 or not. There were in earlier days, there were controversial judgments even by Supreme Court, but now the law is settled that even a security check can be under the clutches of Section 138 if it gets dishonor. But the thing is that when the security stands, the security who takes this stand that it was a security check. If the company, that is the holder in due course, says that Mr. Bhide has given me this security check, then he is duty bound to say that Bhide has given the check for the security of certain performance, and in which he has failed. That's why I owe. That's why he owe the liability towards me, and so it was a check given for consideration. And in other case, if the accused comes with a case that it was a security check and it is misused, then he owes the burden to prove that what was the original contract, what was the liability accepted, whether it is how it is discharged, and then how it is misused. So when I was giving consultancy to one seeds company at Jalna, I modified their basic contracts with their vendors or suppliers. Because taking a signed blank check or post-dated check or a security check is a well-recognized practice in business. How it differs from the legal provision is a different thing. But for making it for consideration, you can insert only a single line in your contract that there are certainly fixed time schedule for the payment or discharge of the liability. If you fail to pay that amount within so and so days, we will be restrained to encash your securities. Under such circumstances, in case of any check dishonor matter, on the basis of the agreement and the dishonored check, I am not required to prove any independent evidence that whether I have called upon him to maintain a sufficient balances in account to honor the check. Otherwise, it will get dishonored. Because if I accept that it was a security check, I should prove that there was certain liability, performance was assured, but he failed. But I am not required to prove such it on the basis of some any additional material if that single line appears in the agreement. So, for example, it was for example only, but such various measures can be taken to avoid the litigations, and that is very much important.
And that's inspiring to hear that, Mr. Vinod. It's always powerful when someone with your depth of experience still speaks with that kind of vision and drive. I think it resonates with anyone looking to evolve, no matter the stage they are at. So we'll quickly move to the next question regarding ESG, as ESG is today no longer just a compliance term. It's becoming a lens through which companies are being judged both inside and out. So from where you stand, Mr. Vinod, how do you see ESG shaping the way companies operate? And more importantly, how legal advisors like yourself guide them through that shift?
So far as ESG is concerned, for sustainable development of not any business enterprise, but for this nation or the whole world, it is necessary. And for that, the basic idea or principle is everything which is necessary to achieve a sustainable and healthy environment for the future generations should be done. And certainly this aspect has reflected in the companies and boardrooms also, because in earlier days there were only 3 P's: known to the companies, that is profit, profit, and profit. But now they are changed by profit, people, and planet. So far as this people concerned is concept is concerned, that the company should do for the others. The others does not mean that the third parties. These others also include their employees, their family members, the society at large, where the plants or offices of the company is situated, located. So that is necessary for the generations to come. And we say in our legal field that it is not only sufficient to do the justice, but it should be seen that justice is done. I stick up with that same concept. And so far as the ESG is concerned, it should not be that we are taking so many efforts for doing it, but it should be visualized. It should be ascertained that it has actually changed the ground reality. And for that, number of efforts are taken by the government or legislature by defining certain norms of reporting and statutory compliances. They are playing a role. There are various NGOs who are also taking efforts in this direction. And with the aid of these, both of them, the corporate houses also do their efforts in that proper direction. I will say that taking efforts for improving the environmental social governance is not sufficient, but its transformation into a visible result which can be seen on the ground is necessary. For achieving the same, industry should pledge for following all the norms, statutory norms, etc. The company should adopt all the standards of business responsibility and sustainable reporting. Utilizing CSR funds also for appropriate cause, social cause, is also necessary, and that will be a measure in that direction.
Absolutely, Mr. Vinod, and that really puts it into perspective. ESG isn't just about reports and ratings, it's about doing business with a conscience.
And this CSR also should reflect in the strategy formulation, policy making, monitoring, and supervising and accountability of the corporate houses. And what is it in at large? If you will permit, I want to read 3 lines from a poem of our late Prime Minister Atal Bihari Vajpayee. पोएम ही सेज, निर्माणों के पावन युग में हम चरित्र निर्माण न भूले, स्वार्थ साधना की आंधी में वसुधा का कल्याण न भूले, माना अगम अगाध सिंधु है, संघर्षों का पार नहीं, किंतु डूबना मझधारों में साहस को स्वीकार नहीं, जटिल समस्या सुलझाने को नूतन अनुसंधान न भूले, स्वार्थ साधना की आंधी में वसुधा का कल्याण न भूले, शीतल विनय आदर्श श्रेष्ठता तार बिना झंकार नहीं, शिक्षा क्या स्वर साध सकेगी यदि नैतिकता आधार नहीं, कीर्ति कौमुदी की गरिमा में संस्कृति का सम्मान न भूले, स्वार्थ साधना की आंधी में वसुधा का कल्याण न भूले, आविष्कारों की कृतियों में यदि मानव का प्यार नहीं, सृजनहीन विज्ञान व्यर्थ है, प्राणी का उपकार नहीं, भौतिकता के उत्थानों में जीवन का उत्थान न भूले, स्वार्थ साधना की आंधी में वसुधा का कल्याण न भूले. In my submission, if
Absolutely.
in literal sense this policy is adopted, that is everything what is required.
Absolutely, Mr. Vinod. And that really puts things into perspective. ESG isn't just about reports and ratings, it's about doing business with a conscience. And it's clear how leaders like you are helping shape that mindset across industries. So before we move ahead, Mr. Vinod, I have to ask, you recently joined Directors Institute, and I'm really curious to hear how that experience has been for you so far.
Yes, I had a very good experience. I have joined your platforms, even the other groups of social media. I could get conversant with another many fields because so far as I found that most of the members available, I could get some more friends also. Most of them are from CA, CS background or some other sectors of business class. Very few I could find from law profession, but certainly that enriched my experience. And so far as the contribution what a director, independent director can play in shaping the decision making in the best interest of the company, I could get various information and insight, we can say, after joining this.
It's so refreshing to hear, Mr. Vinod. It's always inspiring when someone who has already accomplished so much still seeks out growth and new perspectives. It really shows the kind of leader you are. Mr. Vinod, let me tell you what a conversation this has been, from navigating the complexities of law to shaping ethical decision making in boardrooms. Your journey reminds us that leadership isn't just about position, it's about perspective. And I'm sure our audience today is walking away with a lot more than they came with.
Thank you, Mr. Pancholi, for giving me opportunity to share some facts of my career and share with you and the audience. Thank you.
Thank you so much once again. And that's exactly why we do this. Conversations like this one are what FaceTime with Leaders is all about, creating space for real stories, real wisdom, and the kind of insight you don't find in textbooks. Mr. Vinod, thank you once again for your time, your candor, and your leadership. And to our audiences, until next time, stay curious, stay inspired, and keep leading with purpose. Thank you so much and have a nice time.